Hey Chris, how you doing today?
Doing great, Ron. How about yourself?
Not bad. So today we're going to finish out the GDPR versus CCPA and the difference between them. So today's part three, final part, and we're going to talk about CCPA. So on the first webinar, we talked about kind of the differences between the two. The second one, we really dove into GDPR in depth. And so this one, we're going to dive into CCPA and talk about everything CCPA. So tell me, I'm going to hand it over to you and have you tell me what the heck is CCPA? How does it differ from GDPR? And then we'll rip it apart and talk about all the things that make up CCPA.
Okay, awesome. Yeah, so CCPA, just in general, it applies to profit entities that process personal data of residents of California and specifically have 24 million in annual revenue, hold personal data of 50,000 consumers, or have at least half of their revenue from the sale of personal data. And so if your business meets any of those criteria, which for most folks, it's going to be the 24 million in annual revenue, then, this rule applies. And in particular, the sort of key tenets of this are the individuals that this pertains to, residents of California, basically have the right to request their information, data portability, opt out, the ability to access their data, have disclosure, and then to have deletion. And so those are some of the core tenets of CCPA. And so you can see right away that there's definitely a difference there between GDPR and CCPA. And I know, Ron, one of the things that we want to do today is just really highlight some of these key distinctions and sort of where those sit. And in particular, looking at devices, I think is really helpful. So we can kind of understand what physical devices this applies to. Just generally the idea behind some of the commercial processes versus personal, possibly looking at healthcare and sort of how it applies in that space. So I don't know if you want to kind of take it away and dive into some of those topics, but I think that would help folks as well.
Yeah, it's interesting because this one, it isn't just the buyer. Like with GDPR, it's really about the buyer and their transaction in a commercial realm. This one is commercial. It does not apply. The CCPA does not apply to non-commercial use. So if my doctor is treating me, then CCPA doesn't apply to them, right? That's not commercial use. It applies to all items. So it's not just the web, it's telephone, it's mail, and it applies to everyone in the household, which is different, right? It is limited to California residents, but it applies to the entire household. So there are 5 basic premises. So let's go through each of these premises and talk briefly about that. So the first one of the 5 premises is right to notice. So tell us what right to notice means. What is the definition of that? And what does that mean for you if you're a company that falls under one of those criteria that you just set forth?
Yeah, so this is definitely interesting. So we're letting them know that we're collecting their info essentially. And it's definitely a little bit different than GDPR. So we have to let them know, but we can still do it. Whereas GDPR, they have to essentially opt into it up front. So just keep that in mind. It's kind of like in some states where you have to tell the other party that you're recording, but you don't have to get their permission. So it's kind of interesting. So similar idea here with notice, like we have to let them know somehow, but not necessarily get an opt-in essentially.
Right. Yeah, you don't have to necessarily ask for permission. Okay, so the second premise is right to access. Right to access what? Go ahead and tell us what that means.
Yeah, so this is basically talking about the ability to see what is being collected. And, this would generally be sort of like a description of what's being collected. And, we'll kind of get into this later, but typically you're going to combine these into a simple kind of control or even use a SaaS-based offering that's going to take care of a lot of this for you. But we want it to be concise and clear and, let the user know, basically like what is being collected, and they need to be able to access that information.
Excellent. So the third one talks about, you mentioned the opting in. What about their right to opt out, right? And is there time limits, and what's the constraint, and do they have a right to opt out? What does CCPA say about that?
Yeah, they do. And, it is interesting because essentially there is a time period where they, like theoretically, there's a 12-month period. And I would just suggest in general, it's probably a best practice for customers to give them the ability to opt out at any time. That's just, good for customer service and, success with your business typically. But there is a 12-month period, like a waiting period essentially, before they can ask again to opt out, which is kind of interesting. And I don't know if you want to elaborate on that, Ron, and some of the details of it, but essentially they have the right to opt out. And there just is a waiting period after they've made that request before they can essentially do it again.
Got it. So if I go to a website and say, I want to opt out and have you not collect my information, they can put a timer on that. So if I visit the website in 13 months, it can start gathering my information again. And they can say,
Exactly.
we're gathering your information again. It's like, crap, got to opt out again, right?
Yes, exactly.
Got it.
Yep.
Okay. Number 4, and this is kind of an interesting one. I kind of chuckle about it, but you and I've talked about this with HIPAA, where we always say, the government wants to help put guidelines in place so people don't get taken advantage of and businesses don't go crazy. But on the other hand, they're trying to walk a fine line because they don't want to put such restrictions that will put the business out, right? And so they'll have verbiage in there where they'll say at best efforts or make an effort, or these are guidelines, not rules, right? They do a lot of that kind of stuff. And this next one kind of falls under that. So I want you to talk about the right of a resident in California to ask for their information to be, they call it right to request deletion. What does that mean?
Yes. Yeah, this is a really interesting one because just to your point, as you set it up, there isn't necessarily a formal timeline on when that has to be done. So it's like, I have the right to request deletion, but not necessarily formality around when that's going to have to be done to meet this requirement. Again, we would just say, in general, it's best from a customer service perspective to just go ahead and have a higher standard than what the CCPA has, right?
Right.
And like ultimately, one of the big things that we would point to here is that a lot of this can be automated and turned into somewhat of a self-service process, if not completely. But also to your point, for businesses that are just getting going with this, the requirement is essentially vague enough that as long as you have some simple form, some simple way for the customer to make this request for deletion, it can be a manual process to start with. It doesn't have to be automated. And this can be challenging for some businesses too, Ron. And I think you were sort of getting to this as well, is that if you're tracking medical information about that patient, for example, and some portion of their data falls into this request for deletion, and they do in fact request deletion, there's some, sort of culpability or liability around managing their data still if they need those medical records to be kept for a separate sort of, legislation or legal requirements that you have. And so managing that can be non-trivial. And so having it be a gray area, to your point, is a good thing for a lot of businesses that have to sort through the nuances of, well, okay, what can we delete? What do we need to de-identify? And how do we go through that process? And without going into the weeds more, we would just say, like, having a simple way for the customer to communicate that they're requesting that their data be deleted, and that they also get some confirmation that it's in process and that it's been completed. And those would really be the things that we would, strongly recommend. And then having a process internally for how to handle that for typical scenarios. And, I think as long as you're doing something of that nature, you'll be in good shape. And as we've seen, Ron, on these, there's a pretty low volume of these type of requests.
Right.
It's not really something that you're going to typically see a lot of unless you're doing something really aggressive from a marketing perspective.
Yep.
We just don't see a lot of this being an issue with real client scenarios. So
Yeah. Yeah. I'm definitely seeing more of it, right? Because I had 3 conversations last week, literally on HIPAA clients that were calling, talking about projects, and they wanted to use their PHI data about their patients to go aggressively start marketing additional services to them, right? And I said, you got to be really super careful, because as soon as you start marketing to Ron, because you know he's got type 2 diabetes, and so now you market a type 2 diabetes clinic to Ron, you've now violated HIPAA,
right,
right? Now, if you send out a newsletter to every patient to say, here's the agenda of this month's wellness sessions, we'd love to see you there, and it has nothing to do with the patients, it just goes out to everybody, then you're not violating HIPAA, because you're not tying any one of those names to any certain condition. You're letting everybody know these are all the different classes that you're running, and then you're not violating HIPAA. Now, most medical organizations are not going to have to deal with CCPA. At worst, that scenario I gave you, if you are a medical organization, you've got Chris's information, you've got his email, you've got his phone number, and Chris says, I need you to delete. All you really have to do is take him out of your email list, so you're not marketing to him. But for patient and to call him about prescriptions and to set up appointments and stuff, I still need his email, because I have to email his bill. I still need his phone number. So for those services, they don't fall under the CCPA regulation. I just have to remove Chris from my MailChimp email monthly. I'm going
marketing.
to mail him about
Yeah.
something. I just can't market to Chris. And so there's definitely a difference between GDPR and CCPA when it comes to that. Speaking of which, leading into the 5th one, this is kind of the best one, I think. This is where it completely is different than GDPR. This is one that we've seen, and we'll talk about a couple examples here of, you've seen it in the news recently, some big things that have happened. And this is kind of where the government stepped in and said, okay, this is now more of a protection for the consumer, because that's what it's for. It's for the residents now, right? But this is now a regulation on the businesses, not about their information. This is kind of where it I don't know what the word, it derails from information, and it goes beyond that, right? So talk to me about this last one. It says right to equal services and prices. What the heck does that mean? And how does that have anything to do with my information when I'm coming to buy from you? How does my right to equal services and prices have to do with that, or even does it?
Yeah, so this one's really interesting, Ron. This one is essentially saying that, as the name I think implies, essentially there shouldn't be discrimination against consumers by denying goods or services, or charging a different price or rate, providing a different level or quality of goods or services based on the consumer's exercise of any CCPA rights. And
Right.
so I think that's kind of an interesting detail. And now I'm reading this. I'm reading this from a law firm's website. And one of the things that we want to say to viewers is that Ron and I are not legal counsel, and we're not privy to the context of your specific scenario.
Right.
So don't take this as legal advice. Hopefully, it's educational to share what we're interpreting things as based on our experience and what we're seeing. But ultimately, what you will probably want to do, if you have enough revenue and enough business going through California, is that you actually talk to a qualified legal counsel who's going to go through this with you. But
Yeah.
for what it's worth, this is really meant to say that, again, sort of from my interpretation, you're not going to discriminate against someone if they opt out, essentially. And so I think it's easy to sort of conflate this with a bigger scope, but that's basically what it's saying. So if somebody is, it goes on to kind of talk about how somebody does opt out or opt in, you can give them a discount if there's value in their opting in to certain data, but you have to be able to show that you're not discriminating by doing that. And that's challenging. Right. So it's definitely interesting. And you can easily see how people's choices and how they answer questions about their choices could impact, decisions that businesses make. And of course, we want to note that, you just the idea is that you're not discriminating based on the information you're getting with this CCPA, either having someone be part of it or not. It shouldn't cause discrimination or change of goods or services, right?
Right. Yeah. And that one is probably, Chris and I were talking about it, probably the most controversial one, right? As we've seen with even, Israel and Palestine, we've just seen, especially in California and the number of Jews there. I mean, everything is really a hot topic right now. So our best advice, and the reason we bring these up is, again, we're not lawyers, is we just want you to be aware of all these hot buttons so that you can think about it and make good decisions. Talk to your legal counsel, make good decisions, do those things to protect your business, but are also fair, right? And again, I think, Chris, you said it right up front that there was a couple things that smaller businesses, they have to do. What did you say? They have to do at least 24 million a year in revenue before this even applies. Is that what I heard you say?
Yep. That's right.
Yeah. So some of the smaller businesses it doesn't apply to, but that doesn't mean that if you violate some of these premises that they wouldn't file a lawsuit, which we've seen a lot of. So hopefully this was helpful. We really wanted to cover GDPR and CCPA, kind of talk about the different thing, articulate some of the guidelines and what some of the hot spots are, give you the URLs to the site so you've got the right information. And then appreciate any comments you got if you want some more information. And we look forward to you on the next thing. Chris, you want to close us out?
Yeah, I think that's great. If you have questions or you're looking at how this might apply to your business, feel free to reach out for a complimentary review with our team. And otherwise, we'll look forward to seeing you in the next video. Thanks for watching, and bye for now.
Bye for now.